A private bill is one that provides benefits to specific individuals, including corporate bodies. Individuals sometimes request relief through private laws when administrative or legal remedies are exhausted, but Congress seems more often to view private legislation as appropriate when no other remedy is available, and when enactment would, in a broad sense, afford equity. From 1817 through 1971, most Congresses enacted hundreds of private laws, but since then the number has declined significantly as Congress has expanded administrative discretion to deal with many of the situations that tend to give rise to private bills. Since 2007, four private laws have been enacted. Private provisions are also occasionally included in public legislation. The Senate considered private bills using the same procedures that are used to consider other legislation. No House rules define what bill qualifies as private, but most private bills have official titles stating them to be for the relief of named individuals. House Rule 9, Clause 4 prohibits the introduction of consideration of private bills for granting pensions, constructing certain bridges, correcting military owed neighbor records, or settling claims eligible for action under the Tort Claims Act, U.S. Code Title 28. Subject of contemporary private bills and House committees receiving referral of those bills include the following: immigration, domestic claims against the government, foreign claims against the government, patents and copyrights, vessel documentation, taxation, public lands, veterans benefits, civil service status, medical, military declarations. Private bills are introduced and referred in the same way as other measures. They are too commonly introduced by the member who represents the individual to be benefited. Seldom are companion bills introduced in both chambers. Although House Rule 9, Clause 7 permits no co-sponsor on private bills, co-sponsors have occasionally appeared on private bills that attract broad interest. Immigration and claims matters have long been the most common subjects of private bills. The Committee on Judiciary refers these to its Subcommittee on Immigration and Citizenship, which handles them routinely. Under established committee rules, it generally takes no action on a private bill unless its sponsors submit specific documentation and request a hearing. The sponsor is generally the only witness at such a hearing. House Rule 15, Clause 5 establishes special procedures for consideration of private bills. When reported, private bills go on a dedicated calendar. The private calendar, House Rule 13, Clause 1. On the first Tuesday of each month, the Speaker is to direct the clerk to call the bills and resolutions that are pending on the private calendar. Each bill is caught up automatically in the order in which it was reported and placed on the calendar. The bills are considered under a hybrid set of procedures known as the House as in committees of the whole, meaning that there is no period of general debate, but debate and amendment may occur under 5-minute rule. Usually, however, no debate occurs and the private measures are disposed of by voice vote. At his or her discretion, the Speaker may also, on any other day of the month, call up for consideration a bill or resolution that has been pending on private calendars for at least 7 days, providing he or she has given 2 legislative days notice of his or her intention to do so. During the call of the private calendar. If two members object to the consideration of any bill, it is automatically recommitted during a Congress. Each party is to appoint an official called objectors who are responsible for examining bills on the private calendar and objecting to those they deem inappropriate. Sometimes a member of a subcommittee dealing with immigration or claims has served at the same time as an official objector. In practice, instead of objecting, objectors may ask that a bill be passed over without prejudice, which gives sponsors an opportunity to discuss concerns with them informally before the next calendar call. If a private bill is recommitted, the committee may re-report it as a paragraph of an omnibus private bill, which has priority for consideration under Rule 15. At this stage, the substance of each original private bill may be defeated by majority vote by means of a motion to strike the paragraph out of the omnibus bill. Otherwise, each paragraph may be amended only by reducing the amounts of money or providing limitations. After an omnibus bill is passed, it is broken up again into separate bills for further action. In a recent practice, committees seldom re-report private measures once they are recommitted, and the House does not appear to have considered an omnibus private bill in decades. The House has sometimes considered private bills using other mechanisms, such as the suspension of the rules procedure or by unanimous consent. Further procedures on private bills followed the general law-making process. Presidents have vetoed private bills, sometimes by pocket veto. Otherwise, Congress may override the veto in the same way as public measures. Either House of Congress may also, by resolution, refer a private claims bill to the Court of Claims for a recommendation from a trial commissioner. These recommendations are requested occasionally and are strictly advisory, but they are often followed when requested.